withdrawal was couched in some very strange terms.
Yes.
The state attorney sort of tried to leave alive the cost order. There was something very peculiar about that. I'm not so sure what he was withdrawing and what was withdrawn.
Yes. No, my Lord,
that's why I'm saying to you, there might well still be a germ of
life.
Of life.
No, my Lord. No, your Lordship is quite correct. In fact, it was so peculiar that I even acted for the applicant, remember, as an officer of the court, because they were not here in the legal sense. This is what happened. Your Lordship is quite correct. What happened is that they claimed that they were not aware of the withdrawal of the matter by the current president. The record will show the state attorney, Mr. Cho, stood up here and said that is not true, effectively. I'm paraphrasing. He said, he put it in nice, polite political terms. No, there were engagements or whatever. But the point of the matter, the bottom line was that it was not true that they were only becoming aware of that fact as we were sitting here in court. And I even said, when I was now acting for my client, that is to be expected. It's not possible that there was just a withdrawal of a case that involved one president by another without those engagements that Mr. Chowe was talking about. So that's why they did not participate at that stage. And what this court did was simply to say, okay, as far as whatever happened or did not happen, as far as the party that is before us, namely the president of the country, you can't stop them from withdrawing the matter if they want to withdraw. All you can do, as your Lordship pointed out earlier, is simply to give a cost order against them. That's why we have those two orders in page 214. Withdrawal, and then they must pay our costs. So that's the brief history of that aspect. None of it can serve to breathe even a germ of life into the current proceedings, because the current proceedings by that action were finished. But here's another point, Madam. You see, we cannot take this thing of the separation of the president person and the office. We mustn't take it to ridiculous proportions. The president or Mr. Zuma knew, as indicated in that affidavit, that there was a cost order against him. So even from a res judicata point of view, he's going to come to the same cul-de-sac. Because if he knew that and raised it, Justice Hughes has alluded to that, and raised it in the previous proceedings, then he lost that point, so to speak, because this court nevertheless granted the personal cost order against him. That point cannot now be revived in these proceedings. Why is that so? It is because, my lords and my lady, the fiction, we must live with the fiction of the person and the office, but we must also live with the reality, which is that the so-called application for leave to appeal here is nothing else but an attempt to revive the application to leave before. I'll demonstrate that in 1 second. If you go to page 118, page 117, then put your finger there at 117, and then go to page 41. You will find a miracle. Word for word, literally, comma and full stop. Paragraph 2 at 117 is paragraph 1 at 41. Exactly, word for word. It's cut and paste. Paragraph 3 at page 118 is paragraph 2 at page 41. Word for word, everything. Paragraph 4 at 118 is paragraph 3 at page 41. Literally. What does that mean? What it means is that appeal, leave to appeal, which the president, as as president of the country, was raising in December is exactly the same thing that he's trying to raise now. Exactly, but exactly. And so he knows that if he thought, no, that order was just for the office, I mean, for him personally, as Mr. Zuma, and not for the office, then he would not have raised it in his notice of appeal in December 2017 when he was still the president of the country. So it's exactly the same point that he's trying to raise here. And therefore, we can't, with the greatest respect, entertain the intervention application on that basis alone, that you are intervening in nothing. And the something that was there was killed, to follow the metaphor, by the court on the 18th of April of this year. So on that basis alone, irrespective of the delay and all that and the reasonableness and all that, there is no way that an application for intervention, if the rule is read properly, can be brought or even succeed at this stage. And if our learned friends are correct that should the intervention application be not successful, then that's the end of this matter. Well, then that is the end of the matter.
Thank you.
Escort, please.
With your leave, we have prepared short heads that we need to hand up. We have provided them to our learned friends for the applicant. My lords, my lady, very simply, KSAC resists and opposes the application to intervene, and I wish to make 3 points as to the grounds for that opposition. The intervention application and the opposition is canvassed in our heads commencing at page 13. But let me not read those to you. Let me summarize the 3 points briefly for you. And they are these. In order to establish a direct and substantial interest warranting intervention, we need to understand what it is that Mr. Zuma is claiming to be that interest. And there seem to be 2 elements to what he claims as his interest. The first is the financial impact of the costs order. He talks about the effect of the personal costs order on him personally having to pay a liability in the millions of rands. And then he couples it with saying that he has an interest in being heard because he says he was not heard previously by the court when the personal costs order was made. So looking at the first claim, which is that the interest is this financial interest in the personal costs order, KSAC makes 2 submissions in that regard. The first is that a costs-only appeal is generally discouraged, and that is what this essentially would amount to. So given that the court, for all of the reasons that KSAC will submit if the leave to appeal application is argued today, the court properly exercised its discretion when it imposed the personal costs order here. Therefore, this is a costs-only appeal, and we say that there are no reasonable prospects that another court could come to a different conclusion to that reached by this court with respect to his conduct of the review application. Secondly, to the extent that he is saying that he was not heard on whatever representations he would make in an appeal, we say that what this means is that we need to understand what he submitted in the original review application in the score and what he would do differently if he was given personal intervention rights now. And in that respect, we submit that what is going on here is unfortunately a familiar pattern of litigation by Mr. Zuma. We submit that this is the pattern we saw in the Nkandla judgment, the pattern we saw in the spy tapes judgment, and the pattern that this court appropriately sanctioned with another personal costs order with respect to the interdict application that he brought to prevent the publication of the Public Protector's state capture report. And it's this pursuit of litigation so as to delay feeling the sting of what the ultimate adverse order of the court would be. So here, merely because he has the opportunity to try to launch these proceedings and pursue an appeal, and he repeatedly in his papers says that he will take it to the final apex court, so we're looking at potentially 2 rounds of appeal. We submit that this is all to delay and avoid having to pay the costs order that has been appropriately imposed here. So when he says that he has this direct and substantial interest in making further representations, CASAC says 2 things. One, there are no new representations that can be made, as my learned friend, Mr. Mpofu, pointed out. All of the grounds of opposition, his interest now purely as a private citizen in this question of whether the remedial action was appropriate. We submit that all of those issues were canvassed in the original review. There is no new interest that he has in running the identical argument, but now just in his personal capacity. So CASAC submits, in addition, that this indirect interest that he at best has, because it's an interest that sounds purely in money, at best we would say that it's also relevant for the court to look at when that interest arose. And I don't wish to traverse the ground that the court has already canvassed with my learned friends, but CASAC would submit that at least the earliest possible opportunity that Mr. Zuma knew that he was personally at risk of liability for costs was in August last year, when it was in the answering affidavits of some of the respondents. He took up that issue in his papers in the review at that time. Even if we move forward to the point where the judgment was issued on the 13th of December, again, he could have intervened in his personal capacity at that stage. He did not. When he launched the leave to appeal papers later in December, again, he raises the personal costs order issues and, in fact, raises the fact that he's not joined and cited in his personal capacity and does nothing to intervene at that stage. Then, once he's resigned from office in the middle of February, again, the interest has arisen at that point, and he does nothing for a further 2 months. I don't want to go into the condemnation grounds, but he does say, all he says is that from the time I resigned, I was very busy moving house, adjusting, assisting with transition, and addressing political tensions at the time. Certainly, those don't explain why he waited until June before he launched. So even if it's in April, when the current president withdraws the notice for leave to appeal, that this personal indirect interest finally arises for him, he doesn't explain why he again takes nearly 2 months before he does anything. So while we know that Rule 12 requires that this application must be seriously made, it must not be frivolous, we would submit that for all of those reasons, the delay, the repetition of representations that were already made, considered, and played a role in this court's decision to impose the personal costs order, we would say that for all of those reasons, this is not a seriously made application. It is not an application that should detain the courts and clog up the scarce resources and attention of the courts and these parties. So we would submit that he has not made out the type of direct and substantial interest that would warrant intervention.
Thank you.
Now, we all know that a mere financial interest is not justiciable when it comes to intervention or joinder. Are you saying that a cost order is a mere financial interest and that there's no legal interest involved?
Yes, we say that essentially because he has disavowed all of the other grounds of appeal, because he has disavowed this interest in the separation of powers issue as he describes it, because he has said and acknowledged that he can't pursue any of those potential legal interests, the constitutional issues that could have been raised in the appeal. All that's left is merely the cost implication, the financial implication of the cost order. So we would equate that, the pure cost order, the fact that he's personally liable for millions of rands, with the type of indirect financial interest that the case law says does not justify intervention. And we would say that that submission is bolstered, that analogy is bolstered by the discouragement of costs-only appeals, which this essentially is.
Yes. Thank you very much.
If I may, my learned friend is allowed me.
Do you allow me?
Yeah, I know where it is. My lord, just wanted to, I forgot to refer the court to a judgment, just in fairness to my learned friend, so that he can deal with it as well. There's a judgment, it's Minister of Local Government versus CISO Development, 1991-1, 677, TKGD, that's the transcript. 1991-1, SA 677, TKGD. At paragraph 6, or rather page 679C per white J, this is what was said, man. And it's the point that Justice Barafakhovic made, and I'll just qualify it later. It says that the fact that a judgment or final order has already been issued is not a bar to leave to intervene being granted. And this is the important part. If the intervention is sought for some legitimate purpose, which can be instituted subsequent to the issue of the judgment or final order. And the court referred to a case of Bart versus Estate Bart, a 1928 case, in which applicant was granted leave to intervene for the purposes of noting an appeal against the judgment. The only point submission I want to make, my lord, is that in assessing that, which is a true statement of our law, nobody can quibble with that. The crucial distinction that must be made is between December 13 and April 18. So if this intervention was in respect of the December 13 judgment and the subsequent leave to appeal, then this would apply. But once you apply this dictum to the 18th April order, then the point I was making then becomes clear, because then there's no more proceedings which can be intervened in. That's what it is. The page, well, the 679 against the letter C, my lord. Yes. And in that, your lordship will also see the reference to the Bart case, which is cited in the escort business. I'm indebted to my learned friend and to
and just President Maledi wrote Mr. Masudu to our
Judge President, my Lord, my lady, the first issue that I wish to deal with is that relates to the importance of an application for leave to intervene. Why is it provided for in the rules, and why is it such an important device in ensuring that parties who are affected by a court order are able to intervene and deal with issues that affect them? So a leave to intervene is a rule, procedure rule, that protects the rights of persons. It affirms the right of access of an individual who was not before a court to intervene at a time that he or she does. So if one has to appreciate the importance of that procedural ruling, one must then come to look at the circumstances that provoke a person to intervene. And there are very unique circumstances in this case, fairly unique circumstances, because we know that even when the president decides to withdraw the application for leave to appeal, he appreciates that there is an aspect of the order that he cannot withdraw. And the aspect of an order that he cannot withdraw is that order that does not relate to him or to the office of the president. In other words, when he files the notice of withdrawal, he says, take further notice that with regards to the appeal on the issue of the punitive cost, the current president is not liable in that the punitive cost order were against the former president in his personal capacity. And as such, we do not purport to act on behalf of the president, we do not purport to act on the former president's behalf in this notice. So the withdrawal is a qualified one. It leaves open, and it could never be correct for the withdrawal to render moot or to render to include that aspect of the order that related to the president, to the former president in his personal capacity. So that matter is parked there, because we have to go to what my learned friend for the UTM says, Mr. Mpofu, that there is a fiction and then there is reality. Let's deal with the reality of this case, and let's be practical, because what the courts are there for what the courts ought to do is to ensure that, presented with unique procedural difficulties, they're able to use their inherent powers to fashion new remedies and new procedural positions that enable a party who wishes to legitimately deal with a matter that they are affected by to intervene. This is a unique case, because what happens is that when the president is still in his position, he applies for leave to appeal and he shoots through the whole order, which would include the personal order. Because as you would appreciate, Judge President and the justices, the president in his capacity as president says, I want the whole order of the court to be said to be upset on appeal. What it essentially means is that if the appeal court were to find that he was not reckless, qua president of the country, if it were to find that he was not reckless, qua president of the country, that cost order falls away. It would fall away. And so he did not necessarily have to split himself as president at the time that he appealed the order. He could say, as president of the country, I shouldn't be settled with the cost order on a personal account because I was not reckless. And that was basically the basis of his appeal at the time. When the new president comes in and says, I'm withdrawing, this president appreciates that the only withdrawal that he can make is a withdrawal that relates to those orders that are relevant for the functioning of the office. So he decides, I'm not going to withdraw that part of the order which relates to the former president in his personal capacity. So the former president then is here. He says, I would have, if this application was not withdrawn by the current president, I would have been able, it would have been easy to argue the case. But now, this order that you've granted, the implication of the withdrawal is that I remain settled with a cost order. And that cost order it's not just an ordinary cost order, which my learned friend for CASAC seems to suggest, must be simply dealt with on the basic principle that appeals relating to cost orders are generally to be discouraged. This is a punitive cost order. It was not just punitive. There were far-reaching remarks made about the conduct of the president, qua president. They were so far-reaching that he ought to be granted an appropriate forum in which to explain himself. And this is important because the forum of the court at the time that the matter was argued was not the forum. We believe the appeal court would be the appropriate forum for him to explain how he came to a point where he decided to launch the review proceeding. In fact, he does that in his application. In his application, he says he took legal advice when he got the report. So he was advised by lawyers. When he appeared before the court, he was represented by fairly senior lawyers that argued on his behalf. And so, if you are to read from the resources that he relied on in order to come to the conclusion that in order to assess his conduct, one must say, and at the very least, it's arguable that a court looking differently would say, if the process that he took in order to reach the decision that he reached, which was launch a review application against the public protest report, if that process it clearly indicates an application of the mind, the fact that he sought legal advice from people, he got legal opinion from people, he was represented here in court by senior counsel, that on its own should not be ascribed to him personally. He's not a lawyer. He was represented by lawyers.
I'm interested in your argument about the order, the 18th April order. And I'm thinking you are meeting the argument raised by Mr. Bofu that these proceedings are dead. What is the intervention about? You can't intervene in dead proceedings. What I'm interested in your argument is, are you suggesting that when this court granted the withdrawal in April, it left an aspect of the proceedings open?
You see, that's why it's a bit important. The question you asked my learned friend from Mr. Mpofu, very first question you asked was whether he should be permitted to even argue the case. Because he had not brought it. There's no affidavit. And Mr. Mpofu, in his submissions, almost started giving evidence and telling the court how this order of the April was actually reached. And if it had been raised in an affidavit, we would have been able to meet it. We would have been able to raise facts that would have explained our absence in April. And why it's important that the court does not place form over substance. And that the court accepts that if that withdrawal by the president could not have included the withdrawal in relation to costs. In fact, it compounds the problem, Judge President, because essentially what that withdrawal does, given that it was done in the absence of the former president, is that it was done without him being heard.
Well, let me stop you there. You were not here. We were all here. Mr. Mancha was here. He had written correspondence to the court saying he wants to intervene.
Yes.
When discussions happened in chambers, he elected not to place himself on record. Hence, Mr. Mpofu says he spoke for some time on behalf of the former president. Now, I'm interested in that part because if there's merit in what Mr. Mpofu is saying,
no, we have problems. Yes,
you can't intervene in their proceedings while here.
Yes.
So that's why I want to hear you. So are you saying one can find in the April order not everything died, as Judge Korokovic says, something else is still alive. That's why we're here today. I think it's important. And once we think about it, you mind if we take our chair? It's a very important thing.
Don't call me when you get a chance to talk. Explore this.
That's right there, honestly.
Yeah? Zuma's lawyer was in court then. Raised Happy? Yeah. Yeah. Okay. Are they taking a fee?
Right, it's on the way. Thank you so much.
Okay.
Are they checking us?
I'll go in the media room. Go, we've got 5 minutes. Hi, it's Erin here from the High Court of Pretoria. Are you seeing me? I'm holding a microphone and I'm wearing a pink top. You're recording. Please record. I'm going to set it look live now. Thank you. Okay. Okay. Cool. You ready? Okay. Former President Jacob Zuma is seeking leave to appeal a customs order against him from last year. Former President Jacob Zuma has approached the North Gauteng High Court seeking leave to appeal a customs order from late 2017. It has a price tag of estimated $10. Start again. Former President Jacob Zuma has applied to the North Gauteng High Court seeking leave to appeal a costs order with a price tag of around 10 million rand. He's told the court through his lawyers that it's only fair he be given an opportunity to respond to the December period. Start with 3 minutes.
Okay, give me this.
We're not going to have time. Okay, here we go.
Yes,
How's the sound? Does the sound good? Sound is good. Can we go? Sound is good, yes. Former President Jacob Zuma has approached the North Gauteng High Court seeking leave to appeal a costs order from late 2017. It has an estimated price tag of around 10 million rand, and soon after that judgment was handed down, the presidency launched an application for leave to appeal. But that was withdrawn by the new President Cyril Ramaphosa in April of 2018, and Zuma's lawyer was present when that happened in this very same court. So the question is why it took Zuma so long to launch a new application in his personal capacity as a private citizen for leave to appeal that costs order, something he only did in the middle of 2018. The Council for the Advancement of the South African Constitution has argued that Zuma's actions here today repeat a pattern long seen before when it comes to the former president and the courts, citing, for example, his conduct in the courts during his Tadler and the spy tapes. The court adjourned briefly for around 15 minutes at 11:15 and will resume at around 30:30. Here in Babes, Pretoria.
Sorry, Masuku, we disturbed you in full strike.
No, so before the break, Judge President, you'd asked me to address the point raised by Mr. Mpofu relating to whether or not it is competent to bring proceedings that, in his words, are dead. Firstly, my Lord, we do not. The order of the court must be read within the context. Within the context it was granted. The parties to that order were entitled to do what they wanted to do with it. The parties to that case. In other words, the president of the country, when he decided that he wanted to withdraw the application, the former president couldn't stop him from withdrawing. Nobody could. So the intervention is brought as a result of the fact that the injury to Mr. Zuma, rather the application of the judgment to Mr. Zuma, becomes more pronounced when that withdrawal is done. And so we would urge the court to have regards to what, Judge President, you correct, I wasn't in the case, the facts that were said by, that were expressed or that were relied on by Mr. Mpofu are facts that are neither in an affidavit, but you say that it's common cause. What is common cause too is that at that very time when the order of April was being discussed, the position of the former president was in fact discussed. That's what I'm instructed. And it was made clear that he intended to intervene.
In fact, what was made clear was the current president was alive, that he didn't want to withdraw him. There was an aspect in the order that affected the former president that he was close to withdraw.
Yes.
That's clear.
Yes. So on that basis, we would say that the principle that Mr. Mpofu seeks to rely on would not apply. There is a further point, which I have no doubt would put paid to Mr. Mpofu's submission. It's a commentary in respect of Rule 12, and in that commentary, when the author deals with intervention at any stage of the proceedings, he says, provided the requisite notice is given, a new party may intervene at any stage of the action, and intervention has been allowed at the trial. The fact that a judgment or final order has been issued is not a bar to leave to intervene being granted if the intervention is sought for some legitimate purpose or for some legitimate process which can be instituted subsequent to the issue of the judgment or final order being granted. All we ask, give us the right to be part of those proceedings so that we're able to challenge the punitive cost order that was granted to the president. The upshot of what Mr. Mpofu is arguing would impose unbelievable prejudice to the president, because to the former president, what he suggests is that a new process be activated. What process? If the president were to say, I beg your pardon, if the former president were to say, I wish to deal with this issue of the cost order, where is he going to start if it is not an application to intervene? He can't just start nowhere. He has to start where it makes sense. And where it makes sense is where we say is a leave to appeal, because he can never come back to challenge the cost order here in this court, in this division. It has to be a higher court that looks at the issues and that makes the determination of whether or not the court was correct to impose a punitive cost order. That said, my Lord, the second issue that my learned friend for the EFF dealt with relates to reasonableness. Firstly, I mean, Honourable Court would be aware, and it raised this issue with the counsel for the EFF, that there was a delay, and he obviously asked for condonation. Matter that my learned friend for the EFF does not deal with at all is that he does not allege that his client would be prejudiced if leave to intervene was granted. He doesn't. And there's a reason why he doesn't. It's because there is no prejudice. And would submit that the issue of reasonableness, based on the notion that this is a frivolous application, it has no merit, it belongs to the application for leave to appeal itself, if we have to argue that portion of the argument, and we'll deal with that at that stage. My learned friend for Kasak dealt with 3 points. I don't intend to deal with the first two. I don't think that they take the matter any further than what Mr. Mpofu had raised. But the third point relates to right to hearing, the right to hearing. If on the arguments raised by Mr. Mpofu, the president were to be barred from intervening, in the sense that he was not granted leave to intervene, and he had to adopt another process to seek vindication from the court on what directly affects him, his right to hearing would be completely curtailed. And as I started off by setting out why the intervention process, the intervention procedure is very important. And I did so and linked that right to intervention to the right to hearing and the right to access the courts, which is guaranteed in the Constitution. So we would say that there is no bar, there is no legal bar. There may be a political bar for that our opponents seek to raise, the frivolity, the alleged unreasonableness of the conduct, the litigious nature of the person they obviously don't hold in high regard. That is not the legal bar. The court exists to uphold fundamental rights. It has to be unwavering in its resolve to do so. It does not have to be persuaded at all by antipathy towards the person concerned. Because we are personally stunned looking at the words used to dismiss this application as an unmeritorious application. That's for the court to decide ultimately. And we hope it does so on the basis that is constitutionally and legally justified. Not on the basis that he's a litigious person or alleged litigious person who has been running around and doing all sorts of things. It's important, my lord, to... Yes, no, but it's been raised with you, my lord, and I'm entitled to rebut it. I'm entitled to say to your lordships, you have been told that the person that is before you is a litigious person. So you must observe the legal propositions that is putting before you through the eyes of what they see as unbecoming conduct. We say ignore that. And I'm heartened by the Judge President's response that the matter will only be dealt with in accordance with the law, which we submit would essentially result, if your lordship, please. Would result, my lord, in the following: an order granted by this court, an order granting Mr. Zuma leave to intervene. And of course, after intervention, an order that he may pursue whatever remedies he seeks to pursue, pursuant to that order of intervention. But of course, we will still have to come back and argue the issue of whether or not this court agrees that he should be granted leave to appeal. So we would ask, with respect, that the court grants that order. It is in the interest of justice that it is done. It vindicates constitutional rights of Mr. Zuma. It is consistent with the court's powers, the discretionary powers that the court has, to ensure that it makes decisions that are enabling. And a leave to intervene would enable the president, or the former president, to deal with the issues that were raised by this court when it granted a punitive cost order against him. We would ask that that order be granted. Those are our submissions.
What's your view?
Judge President, let me firstly speak just on what I feel passionate about where justice is involved, where constitutional rights are involved. I do think that a cost order should really be granted in circumstances where there is no vindication of this higher value, the Constitution itself. We would ask that if you did not grant leave to intervene, that you grant no cost order against President Zuma. But if you dismissed the resistance to the application to intervene, that you grant costs against President Zuma. You grant costs in President Zuma's favor. And there are a number of reasons for it.
But you know what the rule says?
Yes, I'm familiar with the rule.
So you argue against the rule?
No, I'm not arguing against the rule. It has happened many times that the court, because this is a matter that resides entirely within the discretion of the court. I'm saying that we spend a lot of time trying to persuade the court to exercise the discretion that it has in terms of the rules. But we're being opposed on a basis that really doesn't hold water. And we say that position should be, if we do succeed, that we should be awarded costs, because we've been meant to work harder than the folks that.
If you lose, no cost.
If we lose, no cost.
If you wish, you want your cost.
Yes, because we are not, here's the proposition. The applicant is already settled with a punitive cost order. There's already this application is about that. And we would urge the court to realize the importance of allowing him to litigate on this matter. Because essentially, if you impose a cost order, whatever decision he takes in future, it would include challenging the cost order that is imposed by this court. It just becomes more and more compounded. And it becomes excessively punitive and excessively hard. And I don't think that is the intention of the court, to make it unbearable for any litigant to raise their hand to try and vindicate what they feel is a justiciable issue.
I think what you're arguing is that as a court, we should not allow ourselves to be used as an instrument of oppression.
I couldn't have put it better than you've done, Judge President. I'm happy with that. I'll snatch that back.
Thank you very much.
Mr. Court, please.
Can I rise on privilege?
No, I don't know. Are you suggesting that the opposition was unreasonable?
Yes. I certainly, firstly, for the UDM, there was not even an affidavit providing reasons why this point that worried me, when as I acted, almost conceded. It's a fact-based argument. There are numerous facts that my learned friend relies on, which would have made it difficult for us to argue this case, which could have been put in an affidavit, that we could have alerted us to a potential problem for our case. That facts and evidence is presented before court by counsel. It's just not the right way to do it, because it's prejudicial to us. We need to know what the facts are on which they are opposing us, so that we are able to deal with those facts. We didn't have those facts. But not for the EFF. The only point.
What in your view is an appropriate cost order if we do allow?
No, just a normal cost order.
Namely?
Cost in the result.
Yes.
The usual cost order.
Cost on the court.
Yes. So we're not saying that the opposition should be punished. No, but we're saying that they have added burden to the way in which this case should have been dealt with. That it should attract a cost order, even if we lose. And for as far as the EFF is concerned, the only point they raise is unreasonableness. And with respect, this application for intervention cannot be said to be unreasonable. First, provided for in the rules. And secondly, it's clear that former President Zuma was not a party who could insist on the application remaining alive. The only way he could have challenged a punitive cost order against him was to bring an intervention application, which is what this is. This is. It cannot be unreasonable because the EFF believes that he has no prospects of success in the application for leave to appeal. It just can't be the answer to a opposition opposing a leave to intervene. That would be the same with Kaisa. We would have expected an organization that does champion the Constitution to appreciate the constitutional right that is involved in an application for leave to intervene. And I think it's important that they stay true to what they profess to uphold. And so their opposition to this case is anti their own purpose for existence. We would say it would be justified. And I worked harder than most of them because I had to answer all the time.
So, thank you very much, Mr. Musa.
Thank you.
Mr. Musa.
But on privilege, because I think it is going to be extremely important that the attention of the court, especially in light to page 218 of your papers, especially in light of the criticism that the EFF is getting.
Is this a fair argument or just showing us something?
We are merely bringing the attention of the court to something that informs exactly the arguments that we need. And mainly that, the unreasonableness also can be deduced from what is in this page. And I'll make just one single addition. That is an email that purports to come from the applicant's attorneys, the Bisani Mancha attorneys.
What page is that? 218.
213.
213. Okay.
I'm sorry.
It's an annexure to whose affidavit?
Yes, Lord, it's LPN 5. That's an email that purports to come from the attorney representing the applicant. And what we would like to bring the attention of the court to is that he says he intends to bring relevant applications to join or intervene in the matter as is strictly affected. He will be in a position to file the relevant application by the 15th of May 2018. Now you can never take, we are being accused of holding him to be angry. We now know that he only did that a month later without explaining why he...
Can I stop you there? You said you wanted to bring this to our attention, not further.
As God please.
We seek to go consider our decision before proceeding. No, I thought Advocate Wolf wanted to stand up. I was giving him a stand look that we
yes,
do our work.
Yes, well, it was working, my lord.
We're going to stand down, hopefully for not longer than 20 minutes, to consider what we do. This is an important part of all the proceedings that are before us. So we need to dispose of it first. Yeah.
I merely wanted to add to Mr. Nsabesa's point, my lord, to say that...
Is that argument?
No, my lord.
What is it?
I simply want to say that the email that he refers to, yes, the court must just be reminded that that was in aid of asking for a so-called postponement, which the court did not grant.
Well, there was no formal request for that.
But it said in that same email, yes, there was no formal request. That's good.
Thank you. Will adjourn?
All right.
No?
That's what it is.
They want to do a crossing. Leave this. Hello? Are we going to do a second one here, Jeremy? That's Yes, Jeremy, I can hear you. Can you hear me? Standing by. Right. So Jeremy, now is really crunch time for the 3 justices or judges in the North Gauteng High Court. They need to deliberate and apply their minds to the different arguments they've heard today, chiefly from the applicant here, who is former President Jacob Zuma, challenging that personal costs order for an estimated 10 million rand in legal fees, but also the arguments that they should not entertain this application, which is heard from parties including the EFF, COPE, the UDM, and then also the NGO, the Council for the Advancement of the South African Constitution. Just a few minutes. They stepped down briefly at 12 for about 20 minutes, and these judges are particularly timiest, so it shouldn't be long before we're back in court to hear what their decision is. If they grant Zuma this permission for leave to appeal, then it's very likely the proceedings will kick in right away, and we'll hear his arguments for why he says he shouldn't be mulcted personally to pay these legal fees. And we've already had some indication of what his argument is in his heads of argument and the representations from his advocates here this morning, really saying that he should be given the chance to respond to their judgment of December of last year, where they found that he was reckless in his approach to the courts, and that he should be mulcted personally for challenging the remedial action of the public protector so doggedly.
considered our decision in this matter. Naturally, because of the time constraints, we are not in a position to provide reasons for our order, which will be provided at a later stage. The ruling, therefore, at this stage is that, 1, the late delivery of the third respondent's answering affidavit to the application for intervention is condoned. The third respondent is to pay the costs, if any, occasioned by its application for condonation. 3, the application for intervention is granted. 4, the costs of the application for intervention are to be paid by the applicant. That's our ruling. Could we see both teams just to chart the way forward for the rest of the proceedings? Same place.